There is a date on a document that nobody was supposed to see, June the 11th, 2026. That is the date a private security firm based in Surrey signed a 12-month deployment contract for a family of 4 relocating to the United Kingdom. The scope of the contract is comprehensive: residential protection at a property not yet publicly named, mobile security for school-adjacent routes, medical emergency protocols, advanced reconnaissance of local infrastructure, a confidentiality clause binding both parties. Neither side may disclose the existence or terms of this agreement without written consent. June the 11th. The relocation was not announced publicly until the last week of July. The RAVEC case, the household's ongoing legal challenge demanding state-funded police protection on British soil, was still open. The latest submission from the household's barrister, filed that same month, used one specific word to describe the family's security situation: urgent. No adequate private alternative exists, the filing read. The family remains at elevated risk without state-funded protection. No adequate private alternative. Except that by the time those words reached the court, a private security firm had already been contracted, staffed and paid to provide exactly that alternative. 2 documents, same household, same month, one telling the court that protection does not exist, the other proving it already does. Hold on to that contract. We are coming back to it. The public fight over Harry's UK security is not new. It has been running in one form or another since the RAVEC committee first reviewed his protection status after the couple stepped back from working royal duties in early 2020. The committee downgraded his access. Harry challenged the decision through his legal team. The courts ruled that RAVEC had acted properly, that the review process was lawful, and that the committee was within its authority to assess protection on a case-by-case basis with an advance notice of visits required. Harry appealed. He lost. He appealed again. He lost again. A fresh review was initiated heading into 2026, but the pattern was by then well established. The household would file, the court would review, and the ruling would uphold the committee's original process. Each time, the legal team refined the framing, adjusted the language, brought in new arguments about the constitutional duty of care, about the specific nature of the threat, about the inadequacy of existing arrangements. But the core claim remained constant across every single submission, year after year, unchanged in its essential structure. The family faces genuine elevated risk on British soil. The state has a legal obligation to act, and no adequate private alternative exists. That last phrase did a great deal of work across all those filings. It was the load-bearing wall of the entire legal argument. Remove it and the case becomes something different. Without it, the household is asking for a privilege, a restored status, an acknowledgement that it still belongs inside the circle of state protection. With it, the household could argue that the state had a constitutional obligation to provide what the private market could not. The phrase turned a request into a claim of right, and so it stayed, filing after filing, appeal after appeal. No adequate private alternative exists. Now let me take you inside the room where the private alternative was signed. The account manager who put his name on the deployment contract on June the 11th did not follow royal commentary. His name does not matter for our purposes, but his job title does. He ran the corporate accounts division of a mid-tier British close protection firm, the kind of outfit that provides residential security for executives relocating to the UK, mobile protection for high net worth families, and advanced reconnaissance for corporate events with complex threat profiles. The firm had 14 operatives on its permanent roster and access to a broader network of vetted contractors. It had worked with diplomatic households before. Discretion was its primary selling point. Its office sat above a solicitor's practice on a quiet street in Guildford, and the account manager kept a clean desk, a phone with no voicemail greeting, and a filing cabinet that locked with a key rather than a code. The call came through the household's operations coordinator, not through the legal team, not through a PR intermediary. The coordinator was direct. A family of 4, relocating to the UK by early September. Minimum 12-month contract, renewable. Comprehensive residential and mobile package, and a confidentiality clause. The clause was standard for clients in this category, but the coordinator made it unusually specific. Neither the firm's name nor the client's identity could appear in any public document, press inquiry, industry newsletter, or professional communication without written consent from both parties. The account manager read the brief on a Tuesday afternoon, alone at his desk, with the office door closed. He walked it through with his operations lead before the end of the day. The scope told them everything they needed to know about the client's intentions. residential protection at a named property, mobile coverage for daily school-adjacent routes, medical emergency protocols with pre-identified hospital routes, advanced reconnaissance to begin in late July. The operations lead looked at the deployment footprint and asked the one question that mattered: duration. The answer came back without hesitation: 12 months minimum, renewable annually, not a visit, not a short-term supplement, a deployment. They shook hands across the desk. The contract was signed that afternoon. The same week, in a different part of London, the household's barrister was putting the final revisions on the latest RAVEC submission. The language had been workshopped across several drafts, with the operations coordinator providing specific details about logistical vulnerabilities and the household's exposure during the relocation period. Urgent was in, elevated risk was in, no adequate private alternative exists was in, unchanged from the previous 3 filings. The submission was designed to land with institutional weight, to create the impression that the family's safety on British soil genuinely depended on the state's willingness to act. That without RAVEC's intervention, the family would be exposed, unprotected, vulnerable in a way that the state had a duty to prevent. It was filed and received without incident. Nobody in the barrister's office knew about the Surrey contract. Nobody in the Surrey office knew about the RAVEC submission. The operations coordinator, the one person who sat between both tracks, managed them from the same desk, the same laptop, the same calendar application with 2 separate colour-coded schedules running side by side on the screen. One tracked the legal team's court dates and filing deadlines. The other tracked the security firm's deployment milestones: advanced team visit, route mapping, local police notification, operative arrival dates, equipment procurement. 2 filing systems for one household. 2 incompatible versions of the same family situation on British soil, maintained simultaneously by the same person, saved in adjacent folders. This is where the story turns from a contradiction into a collision. In late July, the private firm's advance team began operational preparation on the ground. 2 operatives visited the UK property over a 3-day period. They walked the perimeter. They photographed sightlines from adjacent roads and public footpaths. They mapped primary and secondary vehicle routes to the nearest school, the nearest hospital, the nearest motorway junction. They timed each route at different hours. They identified blind spots in the property's existing camera coverage and recommended additional installation points. Then they did what every private security firm operating on British soil is legally required to do. They contacted the local police force, they shared the deployment footprint, they named the property, they described the threat profile in general terms. They established a communication channel for incident coordination and agreed on protocols for emergency response overlap. They filed the notification with the local community safety team and received a reference number in return. This is routine. Every legitimate close protection firm does it. The police expect it. The alternative, armed or unarmed private operatives appearing in a residential area without the local force knowing who they are or why they are there, creates exactly the kind of dangerous confusion the notification system exists to prevent. It is also critically documented. The notification goes into a coordination file at the station, cross-referenced with the property address and the firm's license number. Under normal circumstances, that file stays exactly where it is, reviewed only by the duty inspector and the community liaison officer, under normal circumstances. The household's legal team at this point had no reason to believe any of this would surface. The confidentiality clause was tight. The firm's reputation depended entirely on discretion. The advance team's contact with local police was logged in a coordination file that, in the ordinary course of policing, would never leave the station and would never be connected to the RAVEC proceedings running in parallel. But security is a small industry, and small industries leak at the seams. A junior member of the advance team mentioned the deployment to a former colleague over a drink. Not the client's name, not the property, just the scale of the job and the timeline. September start, 12 months, family of 4. Comprehensive package? The former colleague had recently moved into a consulting role adjacent to Metropolitan Protection Circles, advising corporate clients on threat assessment and close protection procurement. He knew enough about the industry to hear the shape of the contract and understand what kind of client it described. He did not need a name. The footprint was specific enough. The information migrated, not dramatically, not through a leak to the tabloids or a call to a news desk. It moved the way most operational intelligence moves in the protection industry, laterally through professional networks, from one person who recognized a pattern to another person who understood what it meant. A security industry contact, someone with decades of experience in close protection and enough institutional knowledge to understand the significance of a private deployment contract running in parallel with an active RAVEC case, confirmed the staffing schedule independently. He cross-referenced the deployment timeline against publicly reported details about the Sussex relocation. The schedule matched the September move almost exactly. The contract was real. The deployment was operational. The firm was staffed and paid. And the RAVEC case, the one still arguing before the court that no adequate private alternative existed, was still open. I want to sit with that specific detail for a moment because it is the hinge of this entire story. The staffing schedule matched the move date. That is not contingency planning. Contingency is a retainer you pay to a firm in case you need them later. A matched schedule is a deployment. It means the family was not waiting on the court to decide whether protection would be available. They had already decided, they had already paid, they had already told a firm to put people on the ground by September. The court case was still running, but the question it was asking, the question it had been asking for years, had already been answered by the household's own checkbook. If this kind of breakdown is useful to you, the like button helps this channel keep reaching people who want the fuller picture. Stay with me, because what happened next is where this story moves from a private contradiction into a public one. The operations coordinator's phone rang on a Wednesday evening. It was the account manager. His voice was professional, but the call itself was unusual. Account managers do not typically phone clients outside business hours unless something has changed. Something had changed. The account manager had received an inquiry relayed through his firm's media liaison from a journalist working on a broader piece about the Sussex relocation. The journalist had asked whether the firm had been contracted to provide close protection for a high-profile family relocating to the UK. The media liaison had declined comment exactly as the confidentiality clause required. No confirmation, no denial, no comment. But the call was a warning. Someone had talked. Not the firm, not the media liaison, someone in the operational chain. The account manager could not say who. He could only say that the inquiry was specific enough to suggest the journalist already had a second source. The coordinator's response, according to the pattern of calls that followed over the next several hours, was immediate and methodical. Within 2 hours, the household's legal team had been briefed. Within 4 hours, the coordinator had contacted the firm's media liaison directly, not through the account manager, to confirm the clause was being enforced and to request that all press inquiries be declined without any form of acknowledgement. Within 24 hours, the next RAVEC submission was being accelerated. The argument was sharpened, the urgency language was intensified. Additional detail about the family's exposure during the relocation window was added to the filing, not because the threat level had changed, not because new intelligence had surfaced, but because the private solution, the one that was never supposed to be visible, was now at risk of becoming public. And if it became public before the court ruled, the central claim of the legal case, the phrase that had carried every submission for years, would be contradicted by the household's own signed contract. The public fight had to move faster than the private arrangement could be exposed. The journalist contacted the firm directly. The media liaison declined again, but the journalist had the contract's existence confirmed by the security industry contact who had independently verified the staffing schedule. The contact was willing to go on the record, not about the client's name, not about the firm's identity, about the pattern. A private close protection deployment, fully staffed and operationally active, running on British soil at the same time as an active court case in which the same household was arguing that no adequate private alternative existed. The story broke on a Thursday morning in an industry publication first, then picked up by 2 national outlets before lunch. The contract's existence entered the public record, not the contract itself, not its financial terms, not the firm's name or the property address or the operational details, just the fact of it. A private security firm had been hired by the Sussex household to provide comprehensive close protection on British soil. The deployment was active and staffed. The timeline predated the public announcement of the relocation by approximately 6 weeks, and the RAVEC case, the one in which the household was arguing that no adequate private alternative existed, was still pending before the court. The security industry contact, asked on camera to explain what the parallel deployment meant for the legal case, delivered one sentence that I think is going to stay with a lot of viewers for a considerable time. You cannot tell a court you have no protection while paying a firm to protect you. Those 2 statements cannot be true at the same time. Sit with that. Because he is not offering a personal opinion, he is describing a logical impossibility. Two documents filed in the same month by the same household. One claiming no private protection exists, the other proving it does. The court was being asked to solve a problem the household had already solved with its own money. And the central argument of the legal case, the load-bearing wall, the phrase that turned a request into a claim of right, turned out to be contradicted by the household's own signed, paid operational deployment contract. The specific price here lands on both sides, and it is worth naming plainly. The account manager's firm loses the confidentiality clause. That clause was the commercial foundation of the entire client relationship. Once the contract's existence enters the public record, the clause is functionally dead. The firm did nothing wrong. Its media liaison followed the confidentiality terms to the letter. But operational security failed upstream, outside the firm's control, and the firm's discretion, its primary selling point in a competitive industry built entirely on trust, is now publicly compromised. For a mid-tier protection outfit that depends on high net worth referrals and word-of-mouth reputation, that is not a minor inconvenience. That is a wound to the business. And the household's public appeal loses its central argument. Every RAVEC submission filed by the legal team over the past several years rested on the claim that no adequate private alternative existed. A signed, staffed, operational 12-month deployment contract with advanced reconnaissance already completed and operatives already on the ground is, by any reasonable definition, an adequate private alternative. The court may or may not revisit the case on these specific grounds, but the public argument, the one that generated press coverage, institutional pressure and considerable public sympathy, is structurally compromised in a way that no future submission can easily repair. The phrase that did all the work now sits beside a contract that says otherwise. I want to be fair here, because the generous reading of all of this deserves genuine consideration before we move forward into the less comfortable territory. Reasonable people arrange private contingency protection while a legal process plays out. That is a common and entirely responsible practice. A family with young children relocating to a country where their police protection has been formally downgraded would arguably be irresponsible not to arrange private security in the interim. The two tracks, the legal challenge and the private deployment, are not inherently contradictory. One is about establishing a long-term constitutional principle. The other is about immediate practical safety while the principle is being decided. Any responsible parent would pursue both simultaneously. That is the strongest version of the counter-read, and I think it deserves real weight rather than being dismissed for the sake of a tidier conclusion. But place it directly beside the specific language of the RAVEC submission. No adequate private alternative exists, not no adequate long-term state solution has been established. Not we have arranged interim private protection but still believe the state has an overriding constitutional duty. The submission said no private alternative exists, period. The contract proved one did. Both documents were filed in the same month. Both came from the same household. Both were managed from the same desk. The generous reading asks you to separate the legal language from the practical reality. The uncomfortable fact is that the legal language itself did not make that separation. It said the thing that was not true. Let me bring this all the way back to where it started. The contract. June the 11th, 2026. A private security firm in Surrey. A 12-month deployment for a family of 4. Residential mobile. Medical protocols. Advanced reconnaissance. Confidentiality clause. Signed, staffed and paid before the relocation was public, before the summer was half over, before the latest RAVEC submission had even reached the court's intake office. I keep coming back to the date, not because dates are dramatic on their own, but because this one tells you something very specific about the order of decisions inside that household. The household did not sign the private contract after the court rejected the latest appeal. They signed it before the court had even read the latest submission. That is not a family waiting for the system to work. That is a family that had already decided the system's answer did not matter and filed the submission anyway. And here is the question that sits underneath all of it. The one nobody in the household's communications office or legal team has publicly addressed. If the private contract was signed in June and the RAVEC submission was filed in June, and both were managed from the same desk by the same operations coordinator, then somebody in that household knew at the exact moment the submission was filed that the central claim inside it was already contradicted by signed contracts sitting in the same filing cabinet, on the same laptop, in the adjacent folder. The question is not whether they were in danger. Nobody here is disputing the threat assessment. The question is why the public fight continued after the private solution was already paid for. And the answer, if you follow the logic of the two documents sitting side by side, is that the public fight was never really about protection. It was about something the private contract could not buy: recognition, acknowledgement from the state, a restored status that money could purchase on the private market, but that only the institution could confer publicly. They wanted the state to say yes, not because they needed the protection, they had already bought it, but because a yes from RAVEC would mean something a private contract could never mean. It would mean the institution still considered them worth protecting. It would mean the system still saw them as inside the circle, not outside it. And the court case, the submissions, the urgency language, the no adequate private alternative, all of it was the mechanism for extracting that acknowledgement from a system that had already, repeatedly, and on the record, said no. That is a specific and uncomfortable reading, and I understand why some of you watching will resist it, because it attributes a calculated motive to a family that may genuinely have believed at some level that the legal fight and the private contract were simply two separate responses to the same problem. I want to leave room for that possibility. But it is also, as far as I can work through it, the only reading that makes both documents make sense at the same time. The generous reading explains the private contract. It does not explain the RAVEC language, and it is the language, not the contract, that creates the problem, because the language said something specific, and the contract contradicted it specifically. The signed private deployment contract, filed publicly beside the still unresolved RAVEC case number. Two documents from the same household, one asking the state for protection, the other already paying for it, the same family behind both, the same coordinator managing both, and the only question that genuinely survives both readings, the generous one and the uncomfortable one, is what they were actually fighting for once the danger was already handled. What do you think? Does the private security contract prove the RAVEC case was always about recognition rather